All right. Welcome, everyone. This is Curt and my colleague,
Brad Binsky.
All right. And we are here for the first file law roundup for 2023. So we're very, very happy to be bringing it to you for 2023. And this year, this program is going to be a special one. We're going to do an annual review of the top 5 cases, but in different categories. And Brad, you're gonna cover what the 5 most interesting.
What I think are the most interesting, yeah.
Yeah, and I've got what I think are the 5 most important. Last night I blogged about what I think are the 5 craziest. And by the way, the same cases can end up on different lists. And I haven't looked at Brad's. I know he hasn't seen mine, so it'd be interesting to see if we agree on some of these in different categories. But Brad, kick us off. What do you?
Okay, yeah, and I have not seen your list, so
I know.
If we go 5 for 5, this is going to be a much shorter show. So listen, we're not unlike, I don't know how you want to do it, but unlike all our normal where we go so much in detail through each one, this will be more of a summary, right? And what I think in October of 22, a FDNY firefighter who is terminated for refusing the COVID vaccine was ordered to be reinstated. Now, there has, to my knowledge, never, except this case, been a successful overturning of a termination. And I don't know that this would actually withstand, an appeal, but nonetheless, I found it so interesting because the judge says hindsight's a powerful tool and goes back and says, listen, the pandemic isn't today what it was a year ago, right? We have more clarity, which is a good point. I'll say the same thing I said before in a minute. But and saying that he says being vaccinated does not prevent an individual from contracting or transmitting COVID. So he had the right to refuse it effectively. And what's incredible, frankly, is interesting, incredible, pick a category. But it says that, listen, we're going to go back 2 years, 2 years, and we're going to determine whether knowing what we know now was justification back then. And, first, this case is incredible because it just overturned a COVID vaccine mandate, which we haven't seen. They're always, right, been supported. But more interesting from a legal perspective is to say we're going to evaluate how you acted 2 years ago based on what you know now. And I just don't think that's the right method of doing things, because at the time we first reviewed this, we had another case on the same week or so, and the employer the employee was being terminated by the employer, and in that case, the employee said, "Listen, just wait another couple of weeks for my medical condition to resolve, and then we can reevaluate this." And the employer said, "We don't have to wait; we're going to evaluate it now." And the employee argued, well, had you waited 3 months, we might have had different circumstances, even though you had the right to terminate. I look at this as almost the same thing. Are we going to really use what we know now to evaluate the decision of the employer back then? So this judge does it. I don't think it's the right way to handle cases. Think of all the things.
I come at it a little different. My undergrad degree is in biology, and I, probably before even thinking like a lawyer, being conditioned to think like a lawyer, I think like a biologist. And there's legitimate reasons why the vaccine is a good idea, and the government should be able to mandate that. That even if today COVID is not as bad, we're still trying to stop the virus because it's going to continue mutating, and who knows what the next mutation is going to be. And if we had everybody vaccinated, I'm just making an argument.
Right.
If everybody was vaccinated. So my point being that can go both ways. And it may turn out a couple of years from now that in fact, the vaccine, if everyone had gotten vaccinated, we wouldn't be in a worse situation than we are today. And I'm just speculating here like that. So, that can come back. That kind of logic can come back. And I think judges should stick with the law, let the medical people stick with the medical, stuff.
Right.
and difficult, a very difficult, controversial issue. But I remember you really took a shine to that case when we first covered it, and I'm not surprised. Now, is that your number one or is that number 5 on your list?
It's just one of them on the list, I think.
Okay.
I don't know that I see, that I try to choose different areas. So in this area, I think COVID vaccine, I think it's clearly the number one because it's the only one that turns out to benefit the firefighter.
It is. And I think there's been a couple of others where things have turned a little bit more in the favor, but certainly that's the biggest one where somebody who was terminated has gotten their job back. Yeah.
Yep. Do you want to play tennis and go to you?
No. Go. Well,
either way.
Yeah, I mean, I was gonna do mine in an order, and I was I was actually trying to figure out if you were going to do the 5th, 4th, 3rd, or if you're doing like the most important.
Doing how I found them. Just doing how I found them. But I think they're all interesting. I mean, and even finding just these 5 was tough. So I'll go for my next ones. So the next one was very recent, but as a somebody who represents a lot of volunteer departments and combination departments. And the question we always get is recruitment. What can we do to recruit? Do we have paid on call in, for example, New York State, or can we give benefits? When we just had this, so I won't get too much into this, but in Washington, where the court, not Washington State, not DC, the court comes out and says, listen, you've got 2 employees here who were working 3,000 hours for more than nominal wages, looked at the totality of their compensation and says, based on the fact that you did standbys for, more than minimum wage, you were actually paid firefighters and not volunteers. And if anybody, I said this then, I'm going to say it again now. And again, it was recent. It was only a month or 2 ago. But if anybody is paying out benefits in any way to firefighters, and you even think it's more than very minimal benefits, having cash equivalents, I think you better get with your attorney, look at this case and make sure you're not violating fair labor standards. Again, what this case did, a couple of big things. One, the court recognized that the individuals who, by the way, the individuals were terminated. All was good when they were there, right? It's like any marriage. Everything's good while you're married.
Yep, that's the way it works.
Yep. So they pissed off 2 people by firing them. The court said, well, listen, these people didn't sign a statement saying they were volunteering, which I think is kind of interesting. They didn't, they said they relied on this income for their normal stream of income, which kind of shows how much it was, right? Much more nominal for somebody to be able to make a credible statement like that. The court found credible. It, looked at, they were doing standbys and making X dollars. They were doing full shifts where the payment was not based on their activity, but based on their hours of their shift, all very critical things. And all that's going through my mind is, I know how creative a lot of fire departments across the nation are trying to be right now to get people to respond. So this issue to me is number one. I know we're trying to save the volunteer fire service and get people to respond, but let's not violate federal law either. And we better look at this. So, and this is could potentially, right, bankrupt, because it doesn't end with 2 firefighters getting 1 year of pay. They get 3 years of pay, maybe times 3. Maybe they could go back 6 years of pay times 3. And then you've opened the can of worms. Now we're going to look at the entire department. And by the way, while we're looking at the entire department, if I'm a plaintiff's attorney, which I was not, or if I was these attorneys, I'd be signing up everybody's neighbors and seeing what their neighbors are doing. I mean, the number of dominoes that falls from this is just astronomical. So that was really one of my, obviously one of my top 5. That
was my number 3. That was actually
okay, all right.
Yeah, so that's good. So, and I disagree with the judge. Well, let me put it this way. I think the judge got it right as far as the Department of Labor has set a 20% rule. Okay. And basically what that means is a volunteer cannot get more than 20% of what it would cost you in terms of compensation, not benefits, but compensation for a full-time employee to work the same shift or work the same hours. You can't pay them by the hour, but you can't, if you give them like a shift stipend or some other type of stipend, you can't make it more than 20%. So I think the court got that part of it right. The court went beyond that, unfortunately. And the Department of Labor has said for decades that firefighters can be paid per shift. They can get a per shift fee. You can't pay them by the hour, but you can pay them per shift. And this is in numerous places by the Department of Labor. And the court said that if you pay them by the shift, it's the same as paying by the hour, and therefore their employees, which I think is it's a terrible decision. It goes against decades worth of
The productivity
and
rule,
also
all that. Yeah.
decades worth of Department of Labor opinion letters on the subject and other paperwork that they've got to train their own people on how to look at it. But the bigger concern is that many fire departments have relied upon those Department of Labor opinion letters and other materials in terms of crafting their benefit program. And this judge unnecessarily upset the apple cart here. And hopefully some sanity will prevail. And, he didn't need to go that far. He could have just said, they're getting too much, it's beyond the 20%, and left it there, but he went a little bit further. So,
and I'm not even sure factually he was right on the 20%. For example, when you look at the standbys, they were getting like $14 an hour, right? But it's 20%.
They're getting $100 for 24, $100 for a 24-hour shift, and $50 for a 12-hour shift.
But yeah, the standbys I'm referring to were like at the games or whatever
well, that was
event
right.
Standbys.
They had a racetrack in the area, and they were getting paid details.
Right, and that would have cost a paid firefighter time and a half, presumably, because you would have been beyond the whatever minimum hours they chose, 128 or whatever. And so I thought it was like 14 or some odd dollars an hour.
Yeah, it was $14, $15, 15 to 20. They actually, one year it was 15, the next year it was $20 an hour. But see, that's a paid detail, and there's a separate set of regulations for paid details that allow an employer not to count those hours worked for the employer. They're worked for a second or third employer, not your basic employer. So a lot of moving parts in that decision, but certainly your admonition that volunteer departments have got to, if you're paying people virtually anything, you need to get with legal counsel, take a look at this decision, take a look at the regs. We'll see if the regs change or if the Department of Labor's opinion letters change after this decision.
And in the attorneys, just so people understand, when an attorney sees a one-off case like this, right, but not an insignificant one-off case, not like Washington State's, most influential state in the nation here, right? But when attorneys see a one-off case like this, it's so very hard to go forward and give you advice, right? And the advice you tend to get is uber cautious, that we have to be so much more cautious because we can't use just what we've known for decades. Now we have to say, well, and it's even worse because, so maybe the rule is more strict than we thought. Look, I hope this gets overturned if that's the way they're going. I can't imagine they're not going to run this right up the appeal chain. But
I don't know if they will, because they're not going to win. They're going to lose on the 20% rule. So if you're going to lose on the 20% rule, why does it matter? Why appeal just to get some dicta clarified?
Yeah,
it doesn't make sense.
Probably
so I hope they do, but I really don't see an appellate court overruling the 20% determination.
No, but I think they could clarify and focus on what the issue is, and then at least help focus the attorneys that this is what you focus on, not maybe the detail, maybe not some other things, but this is what you focus on. And under the correct analysis, right, not going at odds with the Department of Labor, but under the correct analysis, getting to the same conclusion. So all the time we see courts, we affirm but modify the reasoning, right? Now, whether somebody wants to spend the time to do that and appeal that to know they're going to get the same result, who knows?
That's the issue. Yeah.
Okay. Number 3 for me involves marijuana. Why not? So in Buffalo, now this is more of the practical importance of this case. So look, especially now, January 2nd, where I think there was a high number of states who just approved, and it starts January 1st, the recreational marijuana use, right? Which creates so many issues. Many states and many more now have medically authorized or medically certified, never prescribed, medically authorized, medically certified marijuana use. Now, that's what happened in Buffalo. It's not recreational, but it still is going to create problems. So here's what happens in Buffalo. Buffalo, you have a firefighter, 12-year veteran firefighter, who is terminated in 21 because of medically authorized or certified marijuana use. And the CBA at the time dealt with it. But the CBA, this is one of the most interesting parts of this, because if you're one of the states who just legalized, you better amend your CBA or address it. The CBA, what made use impermissible, et cetera, but it did so prior to New York State's enactment or legalization of medical marijuana, which was a long time ago. So it's, incredible how long these things, CBAs don't get amended for. But that aside, all that happened is the city of Buffalo settled the suit for terminating them and, reinstating them, et cetera. But the fact that the attorneys looked and decided, the attorneys for the city decided that, settlement's the best way to go here because it is medically authorized, it raises a lot of issues, right? But it's not a judge's view. Settlement is for a lot of reasons, but this settlement is so significant for a big city like Buffalo, right? This isn't podunk, wherever. Big city like Buffalo to say, we recognize you had the right, legal right to be using medically certified marijuana, and so we're not going to terminate you for it. Now, let me be clear. One of the very important facts: he never used on duty, but that defense assumes that we can tell what impairment is and how long impairment lasts. And right, so using off duty, an hour, 10 hours, 24 hours, 48 hours, like here, we don't legally know, we don't medically know what the length of impairment is and what it does for you. And let me just point out one thing. Marijuana, and nobody's looking at it this way. This is how I look at it. Marijuana has the same effect as an antihistamine. Right now, every interior firefighter hopefully should know that you don't use antihistamines, right? Because they dehydrate the hell out of you. You don't use antihistamines before you go into a fire. You could suffer cardiac arrest because of the dehydration. Now, marijuana is a known vasodilator. So it also dehydrates you, and it has an effect of dehydrating you. I don't know how long that effect lasts for. Is it 12 hours, 24 hours, whatever? But being dehydrated and being an interior firefighter is hugely dangerous. So I look at this another way. It wasn't argued that way, but because the effects of marijuana on firefighting are not yet known, and specifically the off-duty use effects of marijuana on firefighting are not yet known, this to me was huge. Landmark that a big city says, you know what, we're not going to fight it. You get your job back. We were wrong.
I think that what you just argued is something that should have been considered by the state legislature, because the state legislature in New York, and I believe Connecticut, I'm not sure, we discussed this a while back, but I know New York and Connecticut have made the use of medical marijuana a protected disability. So that,
Yes.
Basically, that's okay. But basically, the employee cannot be disciplined or terminated because they're using medical marijuana. So that's a state law, and they are head and shoulders above the rest of the country. And this is my number 5. This was my 5th most important. Okay. Yeah. But the reason being that I think this is what we're going to see more and more of, because I think most states are going to be moving in this direction. Now, certainly not all states, but many states are going to be moving in this direction over the next 1, 2, 5, 10 years. So this could be sort of what we're going to be seeing more and more of.
And the Recreational Marijuana Act in New York State was passed 2 years ago, March, and it was passed in like 24 hours. Yeah. It's mostly modeled after Colorado's law. And I can see there's a lot of places where, and it's the new Colorado's law. Colorado had a good amount of legal challenges and corrected some of them, different topic, but it was done so quickly. And New York made some stupid concessions in their law. They're like, okay, we agree there could be a problem proving impairment. We don't know how impairment can be proved. Look, National Highway Traffic Safety Council said you can't prove impairment. There's no test to do it. There's no way to do it. There's not necessarily an observable effect you can prove impairment with. They put people driving in cars, right? They couldn't prove they were impaired.
I think some of the tests, I don't know if you knew about this. Some of the tests actually showed a decrease in accidents for people who were impaired.
Well, sure, because they're driving slowly or they're sitting in the Pizza Hut parking lot all the time. I mean, one or the other. But New York did it so quickly, as do these other states. But what New York does is say, okay, we're going to fund at a higher institution, learning institution, we're going to fund research to try to find a way to prove impairment. Mm-hmm. Well, you already passed the law. That ship has already sailed. You protected, everybody's rights. And look, I'm not opposed to legalized cannabis products, right? Trump did a lot, as we both know, for the farmers under the Farmers Act to protect hemp, but I'm not opposed to it. But in the fire service, we should be able to prohibit it. Now, this didn't go that far. Just to be clear on this case, this didn't go this far. This just said, look, it's probably a mandatory subject of bargaining, right? It was in the CBA, and you didn't update the CBA. On the other hand, I think this also kind of skips one thought here, because I would argue, look, this didn't get to court, but I would have argued that we did consider it. We looked at the CBA and we decided we didn't want to change it. We liked the rule. So to say that there was a rule in place because before a law was passed, and then to say, well, you didn't consider the new law because you didn't take any action to amend the CBA, I think is wrong. Nonetheless, this shows you the mindset of employers in certified medical cannabis use. And it's a big deal. I'm glad you and I both agreed on that.
Yeah. Yeah.
Okay, I have a feeling this is going to be on yours. You're going to be better speaking on this in mine, but the 11th Circuit Court of Appeals struck down a Palm Beach County social media policy. I thought their reasoning was important. I don't know if you recall this case, but they ruled that social media related First Amendment lawsuit, right? It was filed by 2 Palm Beach County fire captains, and they said it can proceed. They reversed the district court ruling before that. But in doing so, the court struck down the fire department social media policy. And that's what I think is really important here. The social media policy was ruled to be a prior restraint on employee speech, meaning, right, you stopped an employee from speaking before they even said anything because you threatened punishment, discipline, etc. So there was a discipline based on social media policy. I'll kind of read down the facts a little bit as you had them, and then
you should go into it because I didn't pick that one.
Okay,
in my top
good.
5. So.
And it's funny because I have another First Amendment one too. I just, we got a lot of good First Amendment guiding. And let me just say, you say this every time we speak, there's landmark decisions, so to speak, on First Amendment, right? The Pickering rule, but nobody knows what the heck the rule means. It is constantly butchered and interpreted and manipulated and defended. And so it's very difficult to say this is exactly what free speech limitations are allowed, and this is what is not allowed. So here's the short of the, not so short, right? So we have somebody running for union president. And as part of the campaign, he creates an invitation-only Facebook page. Now, so many things go through my mind when you have 2 or more employees speaking on a topic, right? I'm thinking, why aren't we talking some federal laws that protect 2 employees speaking? That isn't the issue of this yet. In any event, so he creates an invitation-only Facebook page, and he posted a comment accusing the union's first executive vice president of attempting to misuse for his personal benefit time that members donated to the pool. So in short, here's what happens. He calls out something, right, an activity that he says is improper, illegal, etc. Now, the first question I'll pose to everybody listening as you're sitting around the table, right, just mesmerized on Curt and I, ask yourself the question, is accusing a union official of misappropriating union funds, is that a employee only matter, like an employee-employer only matter, or does it involve a matter of public importance, right? Is it something that involves that a citizen should be concerned with, that involves a matter of public importance? Anyway, so that's where we're going to end up. So ask yourself that question. I got to tell you, when I first started reading the facts in this, which is why it struck me so much, I was like, I don't know, union theft sounds like an employee issue, although, it maybe not. But I was like, I think the needle points towards it's more of an employee-employer issue, not a public matter of public concern. Right. Nonetheless, that's where I was. That's not where we end up. So there was a back and forth between them, and somebody responded, "Hey, thanks for keeping them accountable." Right. So some internal accountability was praised. Any event, the individuals who commented, one making the accusation, and then the ones who said thanks for holding them accountable, they are then disciplined. And the department claimed that they violated the social media policy. And so the social media policy, let's look at this, because this is, I don't think, so uncommon. This seemed like something lawyers might draft who aren't totally familiar with the First Amendment issue. And it says employees are prohibited from disseminating content that is inconsistent with the duties, conduct, and responsibilities of a fire rescue employee. I mean, talk about vague, all right, including content that could be reasonably interpreted as having an adverse effect on fire rescue morale, discipline, operations, the safety of staff, or the perception of the public. And right there, if an attorney wrote this, clearly when you use a phrase upon the perception of the public, you don't know Pickering at all, right? Because that is just so in the face. In any event, and then it says, for example, unprofessional, unbecoming, illegal, unethical, sexual, violent, harassing, racist, sexist, ethically derogatory comments. And then you have to see how it's written, but it says, comma, pictures, artwork, videos, material, or other such references that all tend to undermine public trust and confidence required by employees. I mean, boy, you start bringing in very First Amendment protected stuff. Anyway, it goes on and then says employees who choose to maintain or participate in social media or social networking platforms while off duty shall conduct themselves with professionalism in such a manner that shall, I love this phrase, not reflect negatively upon this agency or its mission. I cannot tell you how much black ink probably you and I both use when we read someone's social media policy and just don't say anything that could make the department look bad, right? I mean, that is so blatantly unconstitutional. In any event, and then it says failure to comply with the above guidelines can result in discipline. So look, the court struck this down, right? And it struck it down primarily because there was a cold restriction on ice cold restriction on speech about a matter of public concern. And the court says, look, improperly handling union funds, breach of public duty, breach of public trust, all public issues. But it's not that what I wanted to focus on. It is the policy, which we just went through, that I thought was most interesting, because that policy, as you know as well as I, is so common. Don't say anything that makes our department look bad in public. That is just so overbroad, unconstitutional. But I thought the fact that it struck down the social media policy was significant. I thought this gave some good, clear guidance about what not to say in a policy, and what not to do. Saying you can't use artwork, media, videos. I mean, wow, that's pretty broad. So I would that to me is a big one. Mm-hmm. I don't know if you have any other comment, but then my last one. Is it my last one, or did I just?
Yeah, that should be number 5.
Oh, yep. So my last one is from January of 22, when it first appeared on your blog, and so I got to try to remind myself of this. It was in Cobb County. The county prevailed. This is going the opposite way on a First Amendment and a whistleblower suit. So here's what happens: a Georgia firefighter was disciplined after he contacted a county commissioner to voice concerns about apparatus being out of service. Right now, let me focus on one big thing. I'm not trying to, this is kind of a revisiting of the issue. He was it was part of his job duties to staff and man engines and make sure the engines were operating, et cetera. So it's part of his job duty, but he picks up the phone and says, hey, just curious if you know why certain vehicles are out of work or out of service, right? And he gets disciplined for that comment. So the question again, opposite here is he doing that as a citizen, which would be protected speech, or is he making that call as part of his job duties, which likely are not protected speech? And here they said, listen, that was part of your job duties because it's protected speech. But it was such a finicky, the reason I like this for teaching purposes, it is such a fine line, right? Because I frankly have a hard time also not taking the other side saying, questioning whether and why your engines aren't protecting the public seems like a matter of public concern.
It is a matter of public concern. But
so you have now the clash. If something is a matter of public concern, but it's also part of your job duties, when it's part of your job duties to raise a matter of public concern, this court seems to hold you can be punished for it.
Well, let's get into the Pickering because it kind of connects with your last story, right? You got really three moving parts. Okay. You've got matter of public concern as a private citizen. Okay. So those are the two. And then you have the court has to balance, the firefighter's interest in speaking versus the department's interest in shutting them up. So you've got those three moving parts. Okay. Pretty clearly, if you've got, I forget if it was 3 or 4 engines out of service for some reason, that's a matter of public concern. Definitely. Agree, disagree, it's a matter of public concern. Okay. You agree with whether they were out of service legitimately or not. That's what I mean. Did he do it as a private citizen? Well, there's a lot that we can consider in there, but number one, he's on duty when he makes the call. Number 2, he's in uniform.
Right. Okay.
And number 3, he makes that part of the discussion that, hey, we're here doing the staffing. He was from what it sounds like, he was a chief's aide. He was a firefighter rank, so he wasn't a chief officer, but he worked for the battalion chief that was doing, one of the on-duty chiefs that's doing the staffing. And he calls a county commissioner to inquire about why, in other words, to kind of tip off the commissioner that, hey, we've got some companies out of service. Okay. So again, if you take him out of the equation as being on duty, if he was off duty, he makes the phone call, as a concerned citizen, that's one thing. Can an on-duty firefighter make that same call and do it as a private citizen? I think that's an open question. Okay. It's much safer to do it off duty as a concerned citizen. When you're on duty in uniform, and certainly acknowledging that fact that hey, I'm at battalion headquarters, I'm making, it gets kind of hard to say that you did it as a private citizen.
And you only had the information presumably because you were working. The problem I have with this, and it's not that I completely disagree with the holding, all right? The problem I have is on the whistleblower side of this. So now somebody, and I'll defend it with a chain of command argument, but somebody comes across something that they believe is so significant as to threaten the public safety.
Whistleblower is different than First Amendment. Now, here's the thing: you can be a whistleblower, and it not be a First Amendment issue. Now, I'm not sure if I forget the case. I don't know if there was a statutory whistleblower provision. Some people, whenever they alert people to a problem, declare themselves to be whistleblowers. But from a legal perspective, there has to be some sort of whistleblower statute in order for you to really be protected as a whistleblower.
And here, the whistleblower case got thrown out. I agree with why. Right. But because there's a 4-part test, and in the test, it says that the employee has to disclose a violation or noncompliance with a law, rule, or regulation to a supervisor or government agency. And here he said he didn't disclose a violation of noncompliance. Right. He just said, hey, something is, wrong with the engines not being in service. There was no law that required it to be in service. I suppose if there was a minimum staffing or minimum trucks in the CBA, maybe I'm making that up.
Yeah, no, possibly. Yeah.
Right. And so I think the way I would defend this case is to say, listen, there is a chain of command, right? And what makes you the chief's aide or firefighter, or whatever, right? Who, yeah, is vested with looking at this. What makes you so superior that you didn't go to the chief, right? You had to go right up to the top. And look,
it's almost insubordination. You could almost say it's insubordination. Yeah.
Right. And he tries to probably, fend it off with, hey, I was First Amendment or whistleblower or whatever, but it really is a chain of command issue. And it's kind of like the discipline. Just because you don't know what the result is, don't assume that I haven't done anything, right? You don't know that maybe the chief, had you made him aware, or if he was aware, had words with the commissioner. You don't know that, what the reason is, but it's not important for you to know. You have to keep chain of command, right? And I would have defended this, as maybe they had as well, but on chain of command, saying, the reason we have chain of command is so we don't have every first day or whoever person calling the commissioners off say, I don't like what the chief is doing, right? You don't get that in the Army, you don't get in the armed forces, you don't get in the police department, and you shouldn't get it here. So he did violate the chain of command. I think the court had to find this, but I found it so interesting because it's such a fine line between acting as a citizen who easily, had they done the work, could have seen how many engines are on the street and are not, right? It's not like it was impossible information. It was a matter of public concern, but this case really focused on how he was speaking. And, look, there's a slightest factor can tip the scale, but the fact that it was in his job duty and he was on duty when he reported it, that's a big deal. I don't want people to say, by the way, well, I'm just going to make the phone call 5 minutes after shift, right? If it's in your duties, right? But on the other hand, let's change this for a second because it raises the question, right? And the court didn't have to get there, so it didn't go there. What if it wasn't in my job duty? What if I heard from the person whose job duty is, hey, all these engines are out today. And you should, because it's a staffing issue, right? I'm going to let everyone know, listen, guys, we only got 5 engines on the road today, not 9 as we normally do. So just be aware, you're only getting 5 on a, triple alarm or whatever. So everyone would know. And maybe what if the person picks up the phone and says, I'm really concerned. I'm concerned for the public. It's not my job. I'm sorry, Commissioner, but I'm so scared for, wait a minute, still a chain of command.
Yeah, it is. And let me up the ante on that one, because I'm aware of some firefighter unions where you'll have an on-duty union rep holding a press conference in the fire station. Now they're in the fire station on duty, speaking on a fire department related matter, similar to what you're talking about. And I just think you're running a risk. There may be some protection. There's First Amendment issues. There's concerted activity issues. I don't want to kind of confuse those. So when we're talking here First Amendment, but I think you're going to run into that problem that you're not speaking as a private citizen when you are, number one, on duty, number two, in uniform, number three, you're in a fire station. You've got a lot to overcome to say that you're speaking as a private citizen, and that if you're not speaking as a private citizen, you have no chance of First Amendment protection. There may be some other protections that may apply, but there wouldn't be First Amendment protection.
And look, being in uniform isn't the sine qua non, isn't the ultimate issue of anything, and being on duty isn't, but they're all factors. And so just everybody should recognize there's so many factors that go onto these scales, and courts are not consistent, right? Courts are not fully consistent with their holdings, but this helps us really focus on what many other courts before it did. It's not that it was a groundbreaking case, but it's a good case to help everyone understand the speaking as a citizen, matter of public concern type tests. So those are my 5. We're going to get to yours.
Let me get into mine. We're 40 minutes in here, and we really, folks, we try to keep these to 20 to 30 minutes, and it just seems like we're never able to. But I think I'll be able to go through mine quite a bit quicker here because we've already covered a couple of them, right? So I'm going to start with my 5th one. Okay, my 5th, and we'll kind of work our way toward what I consider to be the most important. And the 5th one we've already talked about, excuse me, that's that Buffalo medical marijuana case. And I really think that is the type of case that we're going to be seeing a lot more of as time goes on. So that's why I thought it was important. Number 4 were actually 2 cases in 2 different states, but they were on legislative acts that relate to Firefighter Bill of Rights. The first one that we talked about was Florida. Back in June, they had amended their Firefighter Bill of Rights law, which was long overdue. Florida's law had a number of problem language issues that were in it, and it was one of the problems with Firefighter Bill of Rights is they're often copies of the police officer's Bill of Rights, and which go back 20, 30 or more years. And because they're such a hot topic, nobody wants to play with them. Once they get enacted, nobody wants to go in and correct the language. And as a result, we end up with horrible language in some of the Bill of Rights out there. And nobody really wants to open Pandora's box because you don't know what else is going to get changed. But kudos to the Florida firefighters and Florida chiefs. I'm sure they're both involved in correcting that. But Florida got their language squared away. And then, Brad, your state, New York, in December was able to get a Firefighter Bill of Rights. Kind of went in a different direction than any of the other states. They require that before a firefighter is terminated or disciplined, they have an independent hearing officer, and which I think most of the, I haven't seen any other Firefighter Bill of Rights that requires an independent hearing officer. They all get into what is going to be the limits on the investigators in terms of the questions they can ask, in terms of threats and promises, and how long they can keep somebody in an interrogation and so on. New York went in a different direction, and they require an independent hearing officer, which I think is a terrific direction to go in. So that's sort of my number 4. There was the either the enactment or the updating of Firefighter Bill of Rights. Number 3 was the Washington case, the volunteer compensation case, and I cringe at that decision. Not so much the outcome. I think they got the court got the outcome right based on what is publicly available, but some of the dicta in that case, and for those of you who aren't familiar with the term dicta, it means that things that a court says in an opinion that aren't necessary for the ruling.
And they have no precedential value later on.
Well, but this one, my concern here is that additional language in that decision that says that basically, if you're paying firefighters a per shift stipend, even though it's 20%, it's the same as, for example, paying somebody $1 an hour. If you're paying someone $1 an hour, you have an underpaid employee. Well, what the court said is that if you pay somebody $25 a shift, even though it's 20%, less than 20%, you now have an employee. And I think that's wrong. It's bad.
Scary.
It goes against what the Department of Labor has said. And my concern is that what we're talking about with the FLSA, we're talking about a topic that not a lot of attorneys are up to speed on. They don't need to be. My dad's an attorney, my sister's an attorney. Neither of them need to be up to speed on the FLSA. So the FLSA itself is a specialty. Within the FLSA, the impact of the FLSA on the fire service is like a subspecialty of already something that's a specialty, because there's several thousand lawyers that practice daily on the FLSA. Not all of them are proficient on the 207K exemption, all the different things that go into the fire services aspect of the FLSA. So now it's my turn for my dogs to stop barking, by the way. So if you can hear them. So
can't hear them.
Yeah, so that's good. So they've got to, when a mouse runs across the driveway, they've got to alert the neighborhood. So but at any rate, what we're dealing with is a very, very difficult area, advanced area for lawyers. And judges the same. Judges don't hear a lot of FLSA cases, even federal court judges. They hear them. It's not that they don't hear them, but it's not something that they do every day. I deal with FLSA stuff every day. Courts don't deal with FLSA every day. And even less frequently do they deal with a firefighter FLSA case. So I can envision attorneys that don't deal with this all the time arguing this Washington case to a judge who is not used to dealing with it and saying, well, if it's good enough for Washington, it's good enough for us, and a per shift fee is basically creating an employee, and that's the end of the story, and not really getting the full understanding of it. So I that's why I listed it as one of the most important. Okay. The next one is out of New York, quite a bit out of New York this year, but it has to do with Biancas/Carolyn's Law, which was just signed by the governor over the last week. It was enacted back in June, but it has basically criminalized phototaking of a crime victim. Okay, and you might say, well, what's the big deal there? There's a whole history of cases where firefighters and police officers taken pictures and shared them on social media that has led the legislatures in Connecticut, New Jersey, and California to criminalize phototaking by first responders. New York became the first state that kind of went in a different direction. And what they did was they criminalized taking a picture of a crime victim and then sharing that picture.
And specifically, sex crimes and domestic violence crimes were the two big focuses.
Yeah, but it says crime. It says crime victim, right?
Yeah, but then they focus it, and this is part of my issue with that specific law, not to get too far off track, but they focus, it really focuses on certain articles of the penal code, which are sex crimes and domestic violence crimes.
See, that's a nuance I didn't pick up on. And that actually relieves me a little bit of where I was going with this. Okay. Because you pull up first in at a house fire and you've got a helmet cam going and you happen to catch the victims coming out of the building. And it turns out after the fact, you don't know how the fire started, but after the fact, it was arson. And now basically those are crime victims.
Yeah, it's
right?
not that. It's not. I read this as much more tailored. Am I able to? I don't necessarily want to this second, but I want to pull up as you're discussing that. I have an article where I summarize some of it, but I focus on some of the crimes. I didn't know if I could share my screen and kind of show what they're focusing on.
Should be a little green button at the bottom, center bottom of your screen that says share screen.
All right, keep going through, and I'm going to see if I can pull just that little part.
Yeah, so that was my concern with that. And we, this was one of those stories. We covered it in June when the legislature enacted it, and then we covered it again basically last week when the governor in New York actually enacted the law. So I know I had a couple of folks when I originally posted on it like it and comment that, boy, it's about time. I have a different take on this. I think this is a failure of fire service and police leadership to reel in our people when it comes to picture taking, that we just have not done a very good job of doing it. And when we don't manage this within the fire service, then the only alternative is for the legislature to get involved. And when the legislature gets involved, they do things like make things a crime or issue a fine or some other, sort of heavy-handed way of dealing with this. This should be addressed by fire service leaders, police leaders, EMS leaders. It shouldn't have to fall upon the legislature to do this, but
right. And let me focus. So what they do is you can't photograph a victim, and they define a victim as being the victim of one of the crimes in Title H of the penal law, which is offenses against the person involving physical injury, sexual conduct, restraint, and intimidation. So the crimes you can't take pictures of. And frankly, I think it's a good reaction to something that happened, but it shouldn't be as broad as you were fearful of, but it shouldn't be as narrow as it is, right? So strangulation, homicide, sex offenses, kidnapping, coercion, and related offenses. So those are the crimes that are focused on here. And it really is, frankly, I get it, but it's a little narrow, right? Why? There's never any reason to put in the picture of any victim, but nor of any patient or anything like that. There's HIPAA, obviously, but there's no private right of action under HIPAA. It's just a fine. There's no jail time. It's not, most people aren't really nervous about HIPAA. But HIPAA is very broad, which is not a bad idea. That says you can't put any personally identifiable health information or identifiable information out to the public. So even a license plate, I will tell people, everyone who is saying, X fire department, and putting this on Facebook or whatever, X fire department's responding to a CO alarm at 123 Main Street. I think you're playing literally with fire by violating certain rights and possibly laws, right? Because you're putting out, hey, we're responding to a medical emergency at an address. You can't do that under HIPAA. Now, HIPAA doesn't apply to anyone unless they bill electronically.
You can necessary communications that are necessary for carrying out the care.
But I mean, just putting these on Facebook.
I got you.
Not
I don't want anybody saying
members.
You can't send them out like by I am responding. Or
no, that's totally legit.
Right. It is. And that's what separates, I think, what we're talking about here, which is the dispatch. The dispatch information itself is protected, because how else are you going to alert the companies to go and know where they've got to go? Same thing where the dispatch says, send me an engine company, we're starting CPR or whatever it may be. Or you get a radio report, patient is possibly COVID positive or whatever it is, so that the responders know going in. That's necessary communication. It's no different than a doctor telling a nurse, get me this or get me that. And it might be overheard. But on the other hand, certainly repeating that information, arguably it's a public record, arguably.
Listen to any scanner.
Right. But on the other hand, I think you're right in terms of doing it sort of gratuitously, that it raises a concern here. So I don't want to go over an hour here. So let me get to our last issue here. And this is my number one, and it's actually it's an incident that started, I believe, in 2021, if I'm not mistaken. It might have been 2020. It's the Kobe Bryant helicopter crash. It might have been 2020, I think. Yeah. And in August, the jury returned a $31 million verdict against LA County. That was in addition to several other million in settlements, but $31 million because LA County sheriffs, and the allegation is, and I got some friends out in LA County, so I don't want to say it was definitely firefighters, but there was accusations that firefighters and sheriffs had taken pictures and then shared those pictures, showed those pictures to others of the dead bodies. And apparently the jury agreed $31 million. So that might not be a big verdict for an outfit like LA County. But, think about a small fire department or a small municipality.
And the teaching point on that is because it was I think it was a 1983 action, right? It was a civil rights violation. But what they argued, apparently successfully, right, was that the county either did not have a policy, which it should have had, to prevent the taking of pictures, but or the court, the allegations were that if they had the policy, they didn't enforce it, so it wasn't a real policy. And the failure to have or enforce a policy which you have to protect someone's rights was therefore a violation of their rights. And I think that is such a huge case. You're right. I'm going to steal that from you. But that case I now constantly use in my teaching for that exact purpose. If it's one thing, okay, don't take pictures. It's another thing to say, you got to go to the step further, right? Say, we're going to have and train you on a policy that says you're not going to have pictures. And for that matter, any policy you have, right? As Curt and I will probably tell you, how many policies should you have? It never ends, right? As many problems as you can predict or have that many policies. But you better be able to enforce the policies, and you better train on the policies, because a policy on the bookshelf is going to hurt you worse than not having a policy at all. I'd rather you just didn't have it than didn't have it didn't enforce it. But look, everyone should do, just to finish on your thing, everyone should have a 5-hour, 4-hour, 3-hour end of the year lecture, right? Where you review the highlight from every policy. And look, how long does it take to review on this? Don't take pictures of victims. Done. We don't need to say anything more, right? It's you can cover a lot of policies with a summation. Don't touch people who don't want to be touched. Don't say inappropriate things. Don't fight people. Don't give ketamine when you shouldn't be. And we have some very simple things. So I think if you went back and watched the 100 or 200 or 500 hours that Curt and I have put in this year, and it really is, over 50 or 60 hours of 50 weeks, easily an hour, 50 hours of just delivering the material that you and I have prepared for. But you could take 1 point from every 5 cases and just say, don't do this in a line, and you would protect yourself like in the Kobe Bryant case could have. But not having a policy or not enforcing a policy, I found was the most interesting part of that case.
Yeah. Just having the policy isn't enough. But so that's going to wrap it up for our roundup for today. I do want to really make a sincere request that if you're listening to this and you haven't subscribed, please subscribe. We're up to 750 subscribers. We're really trying to get up to 1,000. That's a big demarcation point for YouTube. It will help us get the word out. The algorithms change once you get to 1,000, so we'll be able to get placement and more people will get to see what we're offering here. So, but this last year has been a labor of love. I know from me, Brad, I'm sure from you, it's a lot of time and effort on our part, but we really enjoy doing it. And please, if you can help us, please click like, and more importantly, please click subscribe. And no cost, it's free. How often do you get 2 experienced firefighter attorneys for free?
Yeah.
Okay, but all right, and that's going to wrap it up for another